Okay, good afternoon, everyone. Welcome to the Data Practices Potpourri webinar with the Data Practices Office. Thank you for joining us today. For those who aren't familiar, the Data Practices Office is a small office in the Department of Administration, and we're a statewide resource on data practices and the open meeting law. Most of what we do is respond to questions related to those laws from members of the public and government. We help the Commissioner with issuing advisory opinions, and we also provide legislative assistance and training. This PowerPoint that we're presenting today is posted on our website, so if you'd like to go back and take a look, it is on the page where you registered. We also record all of our webinars, so if you missed part of today's webinar or want to go back and watch it again, or find one of our prior series, those are posted on the Data Practices Office YouTube page. And I can show you how to find those videos on our website, which is the link on this slide here. Okay, so this is the Data Practices Office website, and as you can see, there's different resources for data practices and the open meeting law, as well as our advisory opinions. You can always find our YouTube page on the footer down here on this icon, or you can go up here to news and events and go to our webinars page. Okay, on our webinars page here, you can actually find more information about audio FAQs. In case you're having any sort of audio issue, there is a FAQ and troubleshooting document there that'll assist with that. And you can also download any of the webinars from our website here. All of our past webinar slides are right down here in these various toggles. And so today's webinar is right there if you'd like to download it. You can also find the Data Practices Office YouTube channel on this page, and so I'm going to that page right now. Okay, so you can find all of our past videos on this YouTube page. We have a playlist for our Potpourri webinars, and the recording from today will be posted here within the next few days. And we also have videos on law enforcement data, personnel data, the open meeting law, social media, and other topics. Okay, in addition to the website, if you'd like to download a copy of today's PowerPoint, I'm going to share that file with you right now for you to download or save to your computer. I'll also do this later in the webinar while we're taking questions, and a pop-up window should appear, and then you can select the file and download to your device. So just one moment. Okay, that file should now be available for you to download, and again, as I said, I'll post it later in the webinar too. So as you're downloading that, just give you an overview of today's agenda. It is our December Data Practices Potpourri webinar, which will be an opportunity to hear what issues data requesters and government entities had encountered this past month in November. As usual, we will leave some time for a Q&A session at the end of the webinar, so feel free to send in your questions as you think of them using the Q&A panel on your screen. When sending in your questions, please send them to all panelists so we can be sure to see them. Okay, in November, we did see many questions about regarding data practice or processing data practices requests. So let's start with this one. Can government entities require data requesters to use a specific form when submitting a request to access data? So the short answer here is maybe entities can require requesters to use a form, and it's ultimately a risk assessment for government entities. Generally, the Data Practices Act doesn't establish specific processes or procedures for how government entities must receive data practices requests. Rather, Section 13.03, Subdivision 2, states that entities must establish procedures consistent with this chapter to ensure that requests for government data are received and complied with in an appropriate and prompt manner. Additionally, government entities must document these processes and procedures in the data access policies required under Minnesota statutes section 13.025. So in other words, the Data Practices Act grants government entities discretion to determine what processes that members of the public must follow in order to submit a data practices request, which may include requiring the use of a form in order to make sure that the entity properly receives the request. Which may include requiring the use of a form in order to make sure that the entity properly receives the request. That said, our office is not familiar with specific cases when Minnesota courts directly address whether government entities could require requesters to use forms to submit a data request. Although not directly discussing the specific context of forms, Advisory Opinions 03-025 and 01-036 highlight that government entities have discretion to require data requests be made in writing and can establish procedures for how data requests must be submitted. Some final notes here. Our office generally encourages government entities to establish multiple ways to accept data requests, such as accepting requests that are directly submitted in writing to an entity's responsible authority. However, that's not a requirement that comes from the Data Practices Act. Rather, we think it's a way to reasonably work with requesters to help ensure that data can be accessed upon request, and we strongly encourage entities to do their best to work with requesters to meet the underlying policy goals of the Data Practices Act. Okay, the next data request related question involves requests for access made by a data subject, and specifically the requirement under section 13.04, subdivision 3, that data subjects must be provided access within 10 business days. So the question is, when does that 10-day deadline start? The answer is that the countdown begins the day after the official receipt of the request. The Data Practices Act is silent about calculating the 10-day deadline, other than noting that the deadline excludes Saturdays, Sundays, and legal holidays. So we need to turn to other sections of the law to help answer this question. Section 645.15 describes the computation of time when a specific duration is prescribed by law. That section states that, quote, time shall be computed so as to exclude the first and include the last day of the prescribed or fixed period or duration of time. The section also notes that the final day must be omitted from the calculation if it falls on a weekend or legal holiday. In those situations, the final day would be the next business day. For the purposes of data subject requests, if the request comes in during business hours on a Monday, then the 10-day deadline would begin on Tuesday. If the request comes in on a weekend, after business hours on a regular workday, or on a legal holiday, then the request would be officially received on the next business day. The 10-day deadline would then begin on the following business day. An additional note here, the countdown begins the day after the government entity receives a properly submitted request according to its written policies and procedures, which may not be the same day that staff become aware of the request. For example, if your policies require that data requests be sent to a specific individual within the entity, but that person happens to be on vacation, the 10-day deadline does not start upon the employee's return. Rather, the 10-day deadline would have started the day after the request was received, whether or not staff were aware of that request. So this is just a reminder that all government entities should have procedures in place so staff know right away when a data request has been received, especially when the request comes from a data subject. Entities should be sure to prioritize those requests in order to meet the 10-day deadline required by law. This next question is another one we've been hearing quite a bit over the past few months from a variety of different government entities. The situations are when a government entity has received a broad data request that will produce a large amount of responsive data and will take several months, substantial staff time, and a considerable amount of financial expenditures in order to complete. The question is whether the government entity can deny the request because it is too burdensome. Okay, let's start with the fact that the Data Practices Act does not contain language that would permit a government entity to deny a requester access to data because the request is overly burdensome or would be too difficult for the entity to compile that data. Additionally, Minnesota courts have declined to recognize that the Data Practices Act contains exceptions to providing access to data due to the burdensome nature of a request. In short, there's no overly burdensome exception to the Data Practices Act. That said, there are a few different customer service strategies that government entities can use to help manage large data requests. So here are some practical considerations that you can keep in mind when working with someone who has submitted a request that will result in a large amount of responsive data. First, after reviewing the request, it's certainly worthwhile to follow up with the requester to clarify that scope of the request. For example, if someone has requested access to all emails containing certain keywords, it's permissible to clarify whether the requester would like data from a particular time period, emails of specific employees, or responsive data that contain a combination of the keywords, etc. Another suggestion is to follow up with a requester to explain that there is a substantial amount of data that are responsive to the request, and it may take a long time to compile. Occasionally, data requesters may not realize how much data they have requested, so having a quick conversation with the requester might help get everyone on the same page. Additionally, it may be a good idea to ask a requester whether certain data should be prioritized when the entity is compiling responsive data, such as providing the most recent data first or data contained in specific types of documents or forms. One other strategy may be to work with a requester to provide data on a rolling basis rather than all at once. For example, an entity can offer to provide a set of data on a biweekly or monthly basis. This may be an effective strategy because it may allow an entity to spread out work while also providing data to the requester over time. Providing data on a rolling basis also allows the requester to assess whether the data is what was expected and can allow the request to be modified, possibly reducing the amount of work needed for the entity and requester. To be clear, these are merely suggestions for customer service approaches that our office has found effective, and the Data Practices Act does not require government entities to implement any of these processes. Entities can determine what internal procedures make the most sense to process data requests to provide access in ways that comply with the law. Alternatively, some requesters may decline narrowing a request or receiving data on a rolling basis. If that's the case, then a government entity is obligated to compile and provide access to data in an appropriate and prompt manner within a reasonable amount of time, which, of course, can vary depending on the size and complexity of a data request. Again, it's up to each entity to determine what procedures will ensure that it is providing access to data in ways that comply with the Data Practices Act. All right, another question we received this past month. A government entity has received a data request for data that is readily available on the entity's website. The question is whether it is permissible that the government entity direct the requester to the website in order to obtain copies of the data. So the Data Practices Act doesn't contemplate situations when a requester asks for data that is readily available on government entities' websites. And Minnesota case law doesn't provide a clear answer either. So the answer to this question is that it may be permissible for a government entity to direct a requester to access data on a website, but an entity should keep several things in mind when considering this issue to ensure it is meeting the requirements of the Data Practices Act. First, the entity should review Advisory Opinion 04-024. In that opinion, a data requester's attorney asked the government entity for a copy of the specific policy the entity maintained. However, the entity did not inform the requester that the data was available online until 6 weeks after the request was made. The commissioner opined that the response to the requester was not timely. Specifically, the commissioner noted that if a government entity is going to offer requesters the option to obtain a copy of data from a website, it must inform the requester very early in the process of responding to the request. This gives requesters the opportunity to determine whether they would like to obtain a copy from the website or directly from the government entity. Additionally, requesters may not have the applicable technology, such as a printer, in order to make their copies of data that are available online. So if the requester does ask for a copy of data directly from the entity, then the entity is obligated to provide a copy to the requester and can assess any applicable copy costs. Another aspect government entities should keep in mind is how requesters are being directed to data available online. An entity would probably not be meeting the requirements of the Data Practices Act by simply providing a link to a website homepage or other general web page. Rather, the entity should provide a link directly to the page or document that contains the data the requester wants to access. In other words, the best approach for an entity is to be as direct as possible if it is offering a requester the option to obtain copies of data from a website. One final thing government entities should keep in mind is whether all requested data are available on a website. Entities should review requests carefully before suggesting a requester access data on a public website. If all requested data are not available online, then the entity may potentially run afoul of the Data Practices Act's requirements to provide data in an appropriate and prompt manner and within a reasonable amount of time. Okay, let's turn to a law enforcement question that we received regarding body camera data, which is governed by Section 13.825. And specifically, that section does not reference juvenile law enforcement data, nor does it consider parental rights of access. So the question is whether parents are allowed to view or obtain copies of body camera data about their minor children. Generally, parents can access private data about their minor children under the Data Practices Act, and body camera data are classified as private when not part of an active investigation. So Section 13.825, Subdivision 4 governs the ability of data subjects to access inactive body camera data. Specifically, Subdivision 4A states that data subjects include, quote, the peace officer who collected the data and any other individual whose image or voice is documented in the data. Additionally, the definition of an individual in Section 13.02, Subdivision 8, clarifies that individuals include a parent or guardian, or an individual acting as a parent or guardian when data involves minors. Oops, excuse me. So additionally, Minnesota Rule 1205.0500 is the administrative rule that clarifies access to private data about minors, and it provides further guidance about access procedures for parents, including situations when parents may be denied access to data about their minor children. So in short, parents are able to exercise any applicable access rights under the Data Practices Act when it comes to data related to their minor children, including the right to access body camera data. Okay, for our last question this month, we do have an open meeting law question, which involved a situation where a member of a public body was diagnosed with COVID shortly before a regular meeting. The question was whether that member could attend the meeting and participate remotely while quarantined. So the answer to this question really depends on the type of public body and whether the body can meet the applicable remote meeting requirements and conditions as required by the open meeting law. So let's briefly walk through the considerations that need to be made for different types of public bodies. If the public body is a state-level entity, then the first section to refer to is 13D.015, which permits members of state-level entities to attend a meeting by telephone or interactive technology. So the conditions that state-level entities must meet under 13D.015 include all members of the participating entity and the public must be able to hear all discussion and testimony, regardless of their physical locations. All members of the public who are attending the meeting at the regular location must be able to hear all discussion and all votes of the entity's members and be able to participate in testimony when applicable. At least one member of the entity must be physically present at the regular meeting location, and all votes must be conducted by roll call. There are also other requirements related to permitting the public to monitor the meeting remotely. However, one of the main considerations to keep in mind in this type of situation may be the notice requirements of Section 13D.015. Specifically, Subdivision 5 requires that a state body post a notice on its website that some members may be participating electronically at least 10 days in advance of a regular meeting. So, if this notice has not been given at least 10 days before a regular meeting, members of state-level bodies cannot attend a meeting via telephone or interactive technology from a remote location. Okay, so let's say the member sits on a local public body, such as a city council, county commission, or school board. Then the body would need to meet the requirements of Section 13D.02, which permits holding meetings by interactive technology so long as certain conditions are met. One important thing to note here, interactive technologies are technologies that permit individuals to see and hear one another. So local public bodies cannot use audio-only telephone calls or conference calls to meet remotely under this section. Again, several conditions must be met for a local body to meet by interactive technology, including all public body members and the public must be able to see and hear each other, as well as all discussion, testimony, and votes wherever members are located. At least one member of the body must be physically present at the regular meeting location, and all votes must be conducted by roll call. Additionally, each location where a member of the body is present must be open and accessible to the public, with some limited exceptions for when public body members are actively engaged in military service or when advised to stay out of public places by a medical professional. However, this latter health exception applies only up to 60 days after a declared state of emergency under Chapter 12 of Minnesota statutes. So it's really this last requirement that would likely create issues if a local public body member was diagnosed with COVID, because any place where a member is attending remotely would need to be open to the public. Obviously, that runs counter to the necessity that the member be quarantined as a health and safety precaution. Additionally, the health exception does not apply in these types of situations now because we are well past the 60-day limit after the state of emergency, which ended on July 1st, 2021. Okay, one other section that may be available is 13D.021, which permits any public body to meet by interactive technology or telephone during a pandemic or Chapter 12 emergency. But again, several conditions must be met. First, the presiding officer, chief legal counsel, or chief administrative officer for the body must determine that an in-person meeting of members of the public body is not practical or prudent because of a health pandemic or Chapter 12 emergency. A clarifying note here. The open meeting law does not describe who determines whether a pandemic is ongoing. So public bodies have some flexibility to determine whether to hold a telephone or interactive technology meeting under 13D.021, even though the Chapter 12 emergency ended earlier this year. Public bodies will certainly want to consider the COVID-19 conditions where they typically meet, as well as guidance from state and federal health officials when considering this option, and we recommend that a body makes a clear determination on the record or adopts some type of resolution that clarifies that in-person meetings are not practical or prudent due to the COVID-19 pandemic. Chapter 12 also permits officials in municipalities and counties to declare local emergencies for limited periods of time. So it's possible that city councils or county commissions could continue to hold meetings under 13D.021 if a local Chapter 12 emergency is still in place. The other 13D.021 requirements include, that all members of the body must be able to hear each other, as well as all discussion or testimony. Members of the public who are attending at a regular meeting location must be able to hear all discussion, and at least one member, the chief legal counsel or the chief administrative officer of the public body, must be physically present at the regular meeting location. However, both of these requirements are contingent on whether attendance at the regular meeting location is feasible due to the health pandemic or emergency declaration. And then finally, all votes must be taken by roll call. One last consideration here is Advisory Opinion 21-003, where the Commissioner noted that if a quorum or more members are attending a meeting in person, then the public body cannot meet under Section 13D.021. In short, when a quorum or more of members are at the meeting in person, the body hasn't met that threshold requirement that an in-person meeting is not practical or prudent due to the pandemic. So to summarize this question as a whole, it may be possible for a public body member who is diagnosed with COVID to attend a meeting remotely, but there are specific requirements under the open meeting law that need to be kept in mind and could possibly create barriers. Public bodies that find themselves in these situations should refer to legal counsel to determine whether all applicable requirements can be met if that member wants to attend remotely. So those were some of our top questions this past month. I'm going to put up the PowerPoint again here in just a moment. We do have some time for questions. So if you haven't already, please feel free to put them in the Q&A panel to all panelists. If we don't get to yours during the webinar, don't worry, we write those down and we can certainly follow up with you afterwards. And if you hear some silence, in the intervening time here, that's just because we are going through some of the questions and making sure that we have good answers for you. Thanks.
Okay, we have a few minutes left for questions. If you have any, please put them in the Q&A panel and we can get to them. At this time, we don't have any, so please feel free to ask away. Thanks.
And as you're thinking about those questions, I am going to open a poll so you can let us know how we did today. And we'd appreciate any feedback that you have on the questions or other topics that you'd like for us to consider in the future. So I'll be opening that poll now. Thank you. So we do have a question here, just taking a look at some of these questions. A few are coming in. Feel free to send them in. We still do have a few minutes. But the question that we have was, when was the data practices and open meeting law resources during a state of emergency webpage last updated? And so this was a webpage that is available on the data practices office homepage. There is a link at the top of that. I believe the last time that we updated that was back in July of 2021. And so some of the information may not be entirely up to date where we are with December. The last big changes that we were really making and focusing on were related to the end of the emergency. And so if you do have questions about data practices or the open meeting law during the state of emergency, certainly feel free to reach out to us and contact us on the various ways to get in touch with us on this slide. And we can certainly provide any additional resources or updated thinking that we have. Thanks. Okay, and so we have just a couple minutes left here. So if you have any other questions, feel free to send those in. Okay, and we will be wrapping up. It looks like things are kind of wrapping up here. And so we appreciate everybody for joining us today. If we didn't quite get to your question or you didn't hear us answer it, we didn't answer many, we will follow up with you individually and chat with you about those questions or provide any sort of links that we might have available. Otherwise, thanks for joining us. Certainly feel free to take a look at our website. We do have some upcoming data practices trainings, and then feel free to sign up for our newsletters and our FYIs that we send out, and kind of the listserv where we will announce future webinars and upcoming different events that we have going on. So thank you and have a great day.